And welcome everybody to the first ever video podcast episode of the Deserve to Win podcast. I'm your host, the Czar of the TCPA, really just kind of the Czar of everything these days, Eric J. Troutman, founder of the Troutman firm, your best alternative to big law folks. But I want to introduce my brand new crew. I'm so excited. And by the way, how awesome is this background? We are at an art studio. I'm going to start with you, Mr. Merlin, because this is your digs, this is your production team, this is your background, your actual art studio. Yeah. PJ, welcome to the show. Introduce yourself to the audience.
So I'm PJ, and I've been in the direct marketing space for 20 years. Email, call center, direct mail, everything, and I'm excited to be here on this podcast.
Now, PJ is a good friend of mine. He's been doing his business better, I think, than anybody out there. He's brilliant, always compliance-minded, and really, he's just a good friend. I'll tell you, I probably wouldn't have had the guts to start the Troutman firm if it wasn't for the support of this guy right here. So I'm really proud, really excited that he's going to be joining us on the Deserve to Win podcast, because this is a guy who deserves to win, I'll tell you. And he's got a nickname, and his nickname is Merlin, because he's a magician. You're going to hear from him in a bit. He's going to break down what call centers can do to be more effective and deserve to win. Really valuable stuff. But sitting to my right, I mean, someone who needs no introduction, but I'll introduce you anyway. It's Queenie. Isn't this fantastic? She's back. You folks might remember from TCPA land, Queenie. She was an absolute stalwart. She was the person that really, I think, drew the most traffic. That's why I had to bring her back. I mean, come on, it's all about ratings. Queenie, say hi.
Hi, folks. Y'all remember me. I didn't really leave, though. I've been in the industry, as you folks know, but now
you left me. You didn't leave the industry, right?
I left your firm, correct. But we still work well together. But yeah, now I'm at this awesome new company. Well, not new, it's a new position for me, Digital Thrive. So yeah.
I think you're general counsel over there or something. Some small title.
I think that's the title. I'm not
sure. Yeah.
I'm still figuring it out. It's new.
So Queenie, of course, one of the best litigators in the nation. She's become a celebrity. No, nothing to do with me. She's just famous out there right now. Digital Thrive, fantastic company. Of course, they were so fortunate to pull Pooja from another great company, by the way, fantastic brand in Loan Depot. Great company. So just tremendous success, follows Pooja everywhere she goes. So hopefully it will rub off here on the podcast, because she definitely deserves to win. Now let's throw it over to Brittany. Hi. Hi, Baroness. Introduce yourself.
Hi, I'm Brittany, but Eric named me the Baroness.
Wait, I don't name people. You're not like a pet. I mean, that's not
disagree. You did
works.
name me Queenie.
Yeah.
Okay, maybe I do name people.
I got my dog's name, so I think I would have preferred the Wizard.
There you go. You named all of us.
All right. Well, we see how this podcast is going to go, folks.
And he named himself the Czar.
That's not true. No, that's not true. That was a borrowed title. But continue.
Yeah, that's it.
That's it? That's all you have?
Yeah.
Are you a lawyer? Do you practice law?
I'm a lawyer.
Yes. Do you have anything to do
law.
with this
I work
area?
at the Troutman firm.
Oh, there we go. Look at that. Now we have a connection.
Yeah.
Do you know who our guest is today? Yes, of course you do. That's why you're listening. Anthony Peronic, the wolf of TCPAWorld, will be joining us in just a few minutes through the power of the Troutman firm to tell you what you can do to deserve to win, and I am so excited to ask him about Berman. I know it's an active case, but I think he's going to talk to me about it. All right, before we get to that, though, let's start breaking down some stuff. We've got to the legal segment before we do some fun. Brittany, boo. Look, everybody that's listening, you folks need to know this, all right? The FTC, Federal Trade Commission, is back to full strength, and they are now democratically led. Okay, we've got 3 Democrats and 2 Republicans, and they're already starting to flex a little bit. Britt, break it down. What's happening over there? What do we expect to see?
Yeah, so the FTC just voted in, his name is Alvaro Bedoya.
Bedoya is a nice guy.
Bedoya.
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 Don't know nationality.
I was wondering how I pronounced that when I was reading your article.
Bedoya.
Yeah, I was trying to practice as well. And
Good.
I think that was my first shot at it.
Yeah.
Hopefully that's right.
I see a lot of articles coming like Bedoya. Anyway, all right, keep going.
Well, later we'll ask Eric to pronounce Massachusetts.
Oh, that's not
that's
nice.
a different story.
That's not nice. All right, so far the viewers know that a guy named Bedoya is involved.
Yeah, just voted in.
Yeah.
He has a background in privacy and consumer data. So as Eric mentioned, there's now 3 Democrats on the FTC with 2 Republicans, so it is Democratic led. and they're hoping to see, or they're thinking to see, that it's going to be, they're going to focus on issues of data privacy and consumer data.
A new NPRM just came out. It's a notice of proposed rulemaking where this is staggering. To me, this is staggering. The FTC is going to require. How can you do this? Every telemarketer out there to hold on to all of their outbound call records for 5 years. Every outbound call record, every record of consent, every single document that they need to run their business. I have to be reading that wrong. That can't possibly be happening in America, right?
No, that's what it says.
That's what it says, just
Yeah.
like that. So, okay, well, I'm glad I got it right. PJ, I mean, you're a marketer, right? You're a call center.
Yeah.
What do you think, man? Is this crazy?
I think it is crazy. Do they want recordings to be stored that long?
Yeah, I think
Almost
so.
everything.
Yeah, everything. So that's going to take a lot of storage. And, it's not easy as a business to just keep all of that for 5 years.
Is that something you saw coming, or is this a surprise to you?
No, I see it coming. I don't know if 5 years is justified. I think maybe if they did 3, it'd be a little bit more reasonable. I think 5 is too much.
Should you weigh? So there's an opportunity to weigh in, PJ. I don't know if you know this. So an NPRM is a notice of proposed rulemaking. The FTC has not yet reached a final order. This is kind of like a tentative ruling. This is what they think they're going to do, but they have to open it up to the public for input. And it might be valuable for them to hear from Merlin that instead of 5 years, you should think about 3 years. I don't know. You think about doing a comment?
Yeah, I would suggest that we all go out there and say, hey, 2 or 3 years. I think 5 years is just ridiculous. That's a lot of storage for small business owners sometimes to store all these records.
Well,
and then what happens if you lose the records?
And that's the irony, right? Because every one of these orders has to have a small business certification, right? There's a special office that you have to have a certification that it doesn't impact small business. The FTC, really weird, said that we're going to waive that, or that can be waived, because we're just going to, I forget what the word is, it was something like, we're going to certify that this isn't going to hurt small business. And I was like, what? How is this ruling not going to hurt small business? This feels like one that's just absolutely going to hurt small business.
I haven't looked into this as much, admittedly, but what is the purpose of saving this? What are they using it for? Right?
I'm glad
so let's
you
start
asked.
that, right?
Yeah.
So 5 years, 3 years, I understand from a logistics standpoint how you're going to store that as a company, but what are the statute of limitations that you're looking at, what you're trying to use this for,
Well,
right?
see,
So that's what I'm curious
Well, and that's
about.
the dark thing, right?
Yeah.
Is they literally admit that they are making you store this so that one day if the DOJ or the AG's office or the FTC comes knocking on your door, that you are going to have the smoking gun still sitting in your records, right? It's like some kind of weird rule that you have to have evidence against yourself that you maintain so that one day you can produce it.
For what?
For criminal prosecution, if you violate the TCPA or if you violate any future law. So this is the other thing, right?
Go ahead.
Let's imagine that next year, no law in the books yet, next year they pass a law that says now it's illegal to make a marketing call or whatever it is. Now you have to maintain those records that will show that you're doing something illegal, not just under the current law, but under that future state law as well. It's crazy.
Overbroad?
No,
much?
to me it's completely unconstitutional. I
Yeah.
did a big article on this, but go ahead, Queenie. I feel like I cut you off there. I just want to get to the Constitution.
No, it's interesting, right? Like from a business logistic point, right? You look at the timeline you have to do it from a legal perspective. I just don't understand the necessity for it. Yeah.
Well, there's no necessity. It's just to give the state, right, the man, the longest amount of time to come after you and prosecute you. It's disgusting.
Wrong. It
It's
feels
a
wrong.
nuisance.
It is wrong.
Yeah,
It is a
it's a
nuisance.
nuisance.
To me, it's absolutely a violation of the Fourth Amendment and the Fifth Amendment. It's absolutely a seizure without probable cause, without a warrant. Now, you're having to seize your own records, but it's absolutely a seizure because you're having to maintain it. They're essentially commandeering, right? If you think about it, what the government is doing is commandeering private server space to hold evidence that they're going to use against the private sector one day in the future. So rather than make you produce it now, because then the government would have to hold on to that, and that would be expensive, they're making you use your resources, literally, I'm not saying you as a general sense, I mean literally PJ.
Yeah.
They're literally making
Yeah.
you store
Right.
this record so that they can one day come after you, PJ, for something you probably didn't even know you were doing wrong. It's disgusting. I'm really very offended by this law. And I think that the way that the FTC has gone about this is both, again, I think it's very unconstitutional, and it really just leaves me with a lot of pause. And I do hope people get out there and start commenting.
Yeah.
You know?
When's the comment deadline?
When's the comment deadline?
I believe it's June 27th.
So it's coming up.
Do you have folks, like clients, that are willing to participate in this?
I'd like to think that I do. You know,
Yeah.
obviously I can't talk about what my clients are considering
Okay.
right now.
Yeah.
But what I will say, you know, to the TCPA world at large, like, this is huge. It's big. My very first podcast episode, I'm leading with this because I think this is, it's frankly, it's world changing. And, you know, once this rule comes out, there's not a whole lot you can do about it. If you want to do something about it, you have to do it now.
No.
Right now is your opportunity.
That's a soon deadline. Yeah.
So let's pivot over to something that I think is also very important, especially in the light of the fact that we've got Anthony Peronic,
Oh,
the
geez.
Wolf. Are you guys excited to see the Wolf, by the
No.
way?
Yeah.
Who's excited to see him?
No?
I'm excited to see what he's got to say.
What he has to say, yeah. I
but
think it'd be interesting.
No.
No, this guy's
I try to avoid him at all costs.
Yeah.
You know, I haven't had any issues with him ever.
Well, look, I like the Wolf. I mean, as you guys know, I like smart people. My clients are very smart people. I love my clients. But the Wolf, he's very smart, too. But he and a group of other lawyers brought down this case called the Berman case. And it's really world-changing. I've been doing a bunch of articles on it on TCPAWorld, of course. But I'm really curious about from your perspective, PJ, and of course, Queenie, your perspective, too, over at Digital Thrive. It's a big change because the Ninth Circuit Court of Appeal, right, not a lower court, a higher court, the appellate court, has said that a button that just says continue, that's not enough to give that consumer knowledge that by clicking that button, they're going to be accepting terms. Even if the terms are right beneath it or right above it, if the terms are too small and that button doesn't have something in it, maybe an asterisk or some other language saying, you know, continue and accept terms, that consumer is not going to be bound. Even if the disclosure says, by clicking continue, by clicking the button, you're accepting these terms. The court says, no. I don't care what the disclosure says, because the button itself, the format of the website, the layout, the experience of the consumer on that website holistically was not sufficient to tell the consumer that by clicking that button, they're accepting legal terms. The court is not going to enforce that anymore. And I've been doing webinars and writing. I mean, PJ, to me, this is a ticking time bomb, right?
Yeah.
People are buying these leads, and they think they're okay, and maybe they're not. What are you thinking, man?
You know, I think there's an interesting point. I think if there's an asterisk and it says by submitting or by continuing, you agree to the terms, and the terms are clear, they're not in a text that is matching the background, they're right underneath the button, and they're very visible to anyone that would look at it in the court. So I think that should be plenty. But you can take it a step further and you can add a box they have to click.
Yeah.
If you really want to be that secure about it. Is it going to affect conversions? I think so. But that's the risk you take as a publisher or a business owner. So I think there's two sides to it. But I do think if it's bold and it sticks out and it's right underneath the button, it still constitutes.
Yeah, okay. Pooja, what do you think? Berman, world changing? What do you think?
So look, for me, one of the worst part of my jobs is going to websites, reviewing my vendors' disclosures and telling them what's wrong with it from a font or color point of view, right? That's not why I went to law school. But more importantly, I think what plaintiffs are angling at is, did the consumer actually consent to being called by your company, right? And that's the biggest thing, right? What these courts are doing is they're not necessarily looking to get granular into the font, the size, etc. They're looking to see, okay, if you're on a car insurance website and you're selling that person's lead for a mortgage, where'd that come from, right? Like, what are you looking at in the website disclaimer? What are you looking at? What are you accepting, right? It all goes back to consent. Did the consumer actually want to be reached by your company or your partner's company? So when you have that in the back of your mind, your disclaimers are going to prove as such.
Transparency, right? If you're taking care of the consumer, the disclaimer, it's no big deal. Like, put it right there, make it clear, and the web form, it really should. I mean, look, I always come back to standards, right? Berman is a shot in the dark because nobody knew that a website disclosure that had a disclosure right next to the button, but because the button said continue, that somehow that was insufficient, right? Nobody's ever said that before. Just because the button says continue, that you can't use it when right underneath the disclosure says by clicking continue, you're accepting these disclosures, right? Berman's the first appellate court case that has ever said that the button alone, standing alone, has to be evaluated to determine whether or not the consumer knew that they were engaging in legally operative conduct, right? No court's ever said that before. I mean, and the takeaway is, I mean, look, if you are in the ecosystem and you pass fraudulent lead, you're going to get sued.
Yeah, and that one was tricky for me, right? It was tricky in the sense where, because I come from the buyer side and the seller side, right? I mean, I'm only 2 months deep into Digital Thrive, but I can already understand how hard they're working to continue to be compliant, right? And so it frustrates me so much to see good guys like Digital Thrive be bad-mouthed by buyers or the litigators, etc. So that case was really important to me, because to me, if the downstream seller was in fact liable or a bad actor, I was on QuoteWizard side from step one, and they try to push it out, but as you see in that case, folks aren't standing up to take liability. They're putting their hands up and they're saying, why me? Why you? Because presumably you offered and you agreed to provide, the buyer, in this case QuoteWizard, a compliant lead for whatever that means to QuoteWizard and whatever that means to the terms. And one of the things that struck out to me was lead seller. I'll continue to call him lead seller. They didn't want to disclose any of their DBAs.
Oh,
Right?
I know.
That
was wild.
And I get it, right, from a business protection and like to protect their company. I get it, but why? Right? Imagine all you folks who are working with that lead seller, and they're not disclosing their other DBAs.
Oh, it's not just the DBAs. They wouldn't disclose their ownership interest.
Absolutely.
Right? I mean, PJ's looking at me with like deep curiosity. Check this out, Merlin. Let's do a quick little thing here. So the federal courts require you to disclose who your ownership groups are for every company, so that the judge knows, for instance, that like, hey, maybe his buddy owns a stake in the company or something, and he might not know that by the name of the company, so you have to disclose ownership. These wise guys, they go to court and they ask this is funny, Brittany, they ask to do this under seal. They say, we don't want people to know, Your Honor, who owns our company. This is the lead seller that supplied the fraudulent lead, the allegedly fraudulent lead, right? For some reason, QuoteWizard's like, that's cool, bro. We'll go ahead and stipulate that you can file that under seal. I'd be like, hell no, man. I'm going to front you. I'm going to put you out on TCPAWorld. But anyway, so they got the permission to do this under seal, and so now nobody knows who the owner of this lead supplier is and what other companies they might own.
Or what other leads.
And what other leads, that's what I'm saying, what other lead suppliers. So these guys could be out there right now
selling you leads.
And you would have no idea.
And the court let them get away with that. I think that was a bad move by the court. But sorry, Queenie, you didn't mean to do a tangent.
No worries. For the biggest takeaway for me is, work with good vendors, understand who your vendors are, do your onboarding diligence, send out your compliance questionnaires. My goodness, how many times do I talk about compliance questionnaires at the conferences I speak at? Get those out, know who you're working with, befriend them, go to lunch with them. My prior supervisor, he told me one thing, he's like, get to know your partners, right? Really, really, really get to know them. A part of your job is understanding who these folks are. And, that's what you got to do, right? In and out, be friends with them. Otherwise, you're not going to know what junk you're getting. So it's crucial for buyers to be in the know.
All right, so look, that's enough of the legal talk, because I am sure that everyone watching this podcast is bored, because you're just here to hear from PJ. So Merlin, let's throw it over to you, man. To all the call center agents out there listening, to all the call center operators, the platforms, the lead suppliers, the lead generators, everybody out there that wants the real wisdom, the street wisdom, right? It doesn't come from us and our highfalutin towers where we live. It comes from guys like you. They're actually out there in the industry, running the call centers, man. So what do you got? What's your perspective?
It's been an interesting year. It definitely seems like it's definitely costing a lot more to dial compliantly.
Ooh, yeah.
Oof.
As a business, I've seen a very big increase over the last few years. You need stir shaking tokens. That costs money. You need more DIDs. And, going back to the point we made earlier, now do you have to store how many DIDs you've had for 5 years or longer?
Wow.
That's a lot of
That's
DIDs,
an amazing question.
Right?
Yeah.
So it's definitely gotten tougher on that scale. But if you're doing it right and you're working with good carriers and you're filling out KYC and you're doing your due diligence, there's still the right way to do it. And it's unfortunate because I do think the people that do it the wrong way, they hurt certain industries. They really do, and that's the unfortunate part. The few bad actors, they hurt industries.
And see, that is one of the things that I've heard over and over and over and over again, right? PJ, you run one of the most respected call center operations really in the world. Pooja, of course, you're GC for arguably the most compliant lead supplier in the world,
Yep.
right? And you folks have tremendous reputations, which bring you all the way to my shores, right? It's why we're having this podcast. It's why so many people want to hear what you have to say. And yet, when you look out there, what you see largely is not a bunch of people emulating you. You see a bunch of people running away and continue to do things the wrong way. I mean, does that ever make you think, why am I doing it the right way? I'm just going to throw in the towel and become a scumbag like everybody else.
All the time. Especially recently, you know, because you start taking hits, you start losing money as a business doing it the right way. And you debate it, because when I was just doing internet marketing by myself, I made a lot more money. So why have all these headaches? Why have all these employees? I question these things all the time, because the bad actors have made it more difficult. Or else the businesses that I have are great businesses.
Yeah. So look, I've gotten to a point where I'm tired of just defending good companies, right? You guys have heard me talk about this. It's time for a trade organization, in my opinion, on the buyer side, a company or an organization I'm calling Responsible Entities Against Consumer Harassment, or REACH. And the concept will be folks that come together and that mandate and require, as an industry, that we're no longer going to allow the scumbags and the fraudulent lead providers and the robocallers who disappear into the night to exist in our ecosystem, right? It's industry finally doing something for themselves, you know, really looking in the mirror and saying, you know what, we're not going to pass the buck anymore, right? We are going to take responsibility for the robocall epidemic the way people like PJ and Pooja have, right? These are companies that are, you know, in my opinion, these are stellar companies. These are companies that people should be trying to emulate. But you hear, right? There's no race to the top. There's a race to the bottom. Everybody wants to do what is obviously easiest, quickest, and most efficient. And if everybody else is getting away with it, if there's no standards, if the buyers aren't saying stop enough, we're not going to allow you to exist in this industry unless you meet these higher standards, then everyone, even, you know, folks that are chiseled out of stone like PJ here, you hear him every day. He's thinking, man, why am I doing this? Am I a sucker, right? And we can't have that. We can't have that anymore in this country, where good businesses are constantly getting sucked into the vacuum of the morass and the swamp of these folks that just get away with doing it the wrong way all the time. So I'm going to do something about it. I've had about enough. I know you're a supporter, Pooja. But anyway, those are my thoughts. I don't know if you guys want to piggyback on that, if we should just get to our guest.
I agree with something needs to be done.
Okay.
Well, Brittany, anything? No? If not.
Okay.
I have one really important question.
Okay, what's the really important question?
Because you did say we're going to get to the fun part.
Yeah, let's do some fun stuff. Yeah, go ahead.
All right, folks, I need you guys to weigh in on this. And Eric, you're going to have to put a poll on TCPAWorld.com.
I'll do it.
Okay?
I'll do it.
Milk or cereal first?
Oh, come
folks?
on. I reject this.
Milk
I
or
reject
cereal
this.
first?
No. People don't even know what you're
You
talking
can
about.
reject
People
it.
don't even know what you're talking about. Like milk or cereal first. Like
No,
what came
of course
first, the
they do.
chicken or the egg? Like people don't even understand the question right now.
Do you
It's
understand
simple.
the question?
I
Do you
understand the
understand
question.
Nobody
the
understands the question.
I think
Well, hang on.
chicken
Let's
You're
frame
very
it.
straightforward.
We have to frame the question properly. You have a bowl.
No, absolutely don't. Wait.
You have to ask the question.
You don't need context.
Eric, you're not
Milk
on
or
social
cereal
media.
first? That makes no sense. Milk or cereal
Everyone
first.
understands it.
No,
Everyone
No, I don't
understands
understand it. You're going to not give the audience any context. Just milk or
Audience,
cereal
if
first.
you understand it,
Well,
answer
C-
it. If you don't, just
C comes first in the alphabet, so cereal comes first. If there's no context, it doesn't make sense.
your audience will understand it.
I don't understand.
Brittany.
Okay, well, there's the question. With that, let's get to the guest, okay? Everybody, in a few moments, we're going to leave the debate about milk or cereal first. I don't even know how to frame that. And get to Anthony Peronic, the wolf of TCPA World. And I am not going to ask him that question. And now, are you guys excited? I'm super excited.
I'm amped.
Through the power of the Troutman firm, we bring you one of the most feared class action attorneys in all of America, certainly one of the best known lawyers in the TCPA world, the wolf of TCPA World, Anthony Peronic. Welcome to the show, man.
Thanks for having me, Eric. Always a pleasure.
Let me just start by saying you are the first guest that we are having here on the new Deserve to Win podcast. And I cannot think of a better guest because, look, man, I have to say it. You've shown over and over and over again that you have what it takes. You deserve to win. And you just crushed a poor defendant in a case called Berman out in the Ninth Circuit. And I want to start with that because it has really, really made waves. We talked about it a little bit earlier in the podcast. I'd love your take. I'm happy to frame it out for you if you'd like, or I'll just kind of let you run with it. It's a great ruling. What do you think?
Well, I think it's a great ruling, but I'll start by saying that I can't take much credit for that. There were other members. I'm counsel of record in one of those cases, but every other member of the team had much more to do with that than I did. But I think the takeaway from it, I don't know what you said earlier in the podcast, but I think your core audience probably has to have one major takeaway from it, which is if you're generating leads off of websites, you need to be doing your front end due diligence, and any assumptions about what you think you may have known for a legitimate consent gathering process, it needs to be questioned. And I think appropriately so, especially if you're on the Ninth Circuit. But the reality is from anywhere, because your calls, the leads you're generating can be going into a jurisdiction where Berman's now going to be the law.
How much benefit do you think you as a class action attorney on the plaintiff side derive from the fact that there's really no standards out there in the lead generation industry, right? Nobody knows how big is too big, how small is too small, what color font against what background, where does it have to be positioned? None of those things are really set forth in the law. Do you find that to be helpful to you, or is that an impediment?
I wish there were some common core values and standards because, while people may believe that individuals on our side of the V can try to exploit the uncertainty, that's not how I practice. That's not how the people that I work with practice. We like the idea that from our perspective, if the standard's going to be clear and conspicuous, it's why we like written consent, right? If the standard's going to be written consent, I know the irony is in the TCPA universe that what written consent can be, consent can be in writing, like a lot of people would assume, right? Or it can be something that's recorded but verbal. But the point is that, the more clear standards that are out there, that's what I enjoy, because if someone departs from what should be the clear standard, I think that's where they're in a position where they don't deserve to win.
Oh, that's good. That's good. Well, hang on, Anthony. Let me ask you, because you just said something I think is really interesting and maybe a little controversial.
No, I wouldn't do that.
Are you in agreement with the proposition that if somebody is recorded being read a disclosure that is consistent with 47 CFR 64-1200 F9, the language is there, and they are recorded and they say, yes, I agree, that can constitute express written consent?
No, but I know that that's an argument that I face.
I was hoping to get you there.
We're waiting for it.
It sounded like you were going there first.
No, but my point is that when you look at a standard and you see a standard of written consent, you would think that it should mean a certain thing. But what I have to concede is that there's a good faith-based argument that it's not so obvious what it means.
So let's pivot back to Berman, because what we were talking about earlier, and what I think, my core takeaway from Berman is that you can no longer have a button or a display for a consumer on a web form submission that does not draw the consumer's attention to the fact that something legally significant is about to happen when they click that button. Now, in Berman, of course, the button just said continue, and the Court of Appeals suggested that it should say continue and accept terms, right, if it was going to be enforceable. Now, I don't think that is the law. I don't think the court was suggesting you had to go that far. Certainly, you have to go farther than just continue these days. But to me, I think, for instance, if there's an asterisk on the button and the terms are right below it and the asterisk is referring to that will be okay. That's just my opinion. You don't have to agree with that. But are you now looking more for web form submission cases in light of Berman? I know the guys over at Seamus and Gentile are doing that. I'm kind of curious what your thoughts are post Berman.
No, because the short answer is no. I'll also say I don't agree with you that necessarily the asterisk will work. But how I've done these cases for over 10 years now, and Ted Broderick and Matt McHugh, who are also counsel of record and frankly more meaningful counsel of record than I am in the Berman case. I've done, over 100 cases with them. We've never gone out and looked for, I think, what you would call a web form case, right? But what we do look for is when we're pursuing these cases on behalf of consumers that we think didn't participate in any survey at all, right, didn't sign up for any of these things, we as litigators are certainly going to be looking for core common issues that we think are worthy of a trial. And I think in some ways, Berman's just an example of one of the very many web form cases that are out there, where if at its core, what you have is a series of calls that were made, and one party is saying that we made them based on these web submissions. We're saying that we don't think those web submissions occurred. But of course, we live in a world of evidence, right? And so we need to be able to present that in a common sense way that supports our goal, which is to vindicate the rights of all the call recipients. And that's the easiest one fell swoop way to do it. But, and I apologize because that's a slightly long-winded answer to your simple question, which is no, we didn't see the decision from the Ninth Circuit and then, go into our evil layer and say, give me all the technical violations we can get. It's just a way of looking at the evidence that's presented in any case and what's the best way to get to a trial. I think what happened in the Berman case happens in a bunch of cases. And I am appetized by these kind of cases, which are, if you're buying leads, right? You're buying leads from a third party. You're doing it wrong if you don't do exhaustive due diligence on the front end. I see way too many cases where the defense lawyer, because of course, in consultation with their client, they're saying that there's a web-based permission for the contact that's at issue. And that's no big deal. That happens all the time. But what always catches my eye is when we're asking any sort of follow-up questions about the legitimacy of the consent, the viability that website visit actually occurred, when the response we get is, oh, well, let me talk to my client who will have to talk to the lead generator, who then has to talk to the data broker, who's going to talk to the website owner. Those are the red flags that we look for.
Out of the words, the gospel from the wolf. And you just heard what makes the wolf appetized is when he gets cases where you've got a bunch of downstream lead providers that can't come up with the evidence. And I remember last time we talked, Anthony, you were kind enough to come on the previous iteration of my podcast, and we had a very similar conversation. And I remember you telling me then, look, what we go for is fraudulent leads. Scenarios where somebody is providing data for a consumer who did not actually sign up on a website. But what you fall back on from a certification standpoint, because it can be challenging to demonstrate that, you don't have to agree with me, it can be challenging to demonstrate fraud from a predominant standpoint, you fall back on the disclosure language format, the consumer experience, and that is where you struck gold in Berman. And that's what, to me, that's what I want people to understand, right? You come for the fraud, and you stay for destroying an entire business practice around what a web submission should look like. And if you are inviting these lawsuits by being undiligent on the front end, knowing who you're working with, knowing who your lead partners are, you're going to invite the wolf to your doorstep, and then everything you're doing, all of the websites, all of your practices are suddenly at issue. And like you just said, you're going to pivot, you're going to find something to hang your hat on to help out that class, and these folks are going to be in trouble. I mean, is that about right?
Yeah, I think in a lot of ways that's right. But again, Berman, it's just a recent decision. And again, a lot of credit is due to the people that were actively litigating that case. But I think that's just a conduit for the discussion we're having. I don't think the takeaway from Berman can be the law, not that the facts were particularly unique. My point's actually kind of the opposite, right? Which is that we see these facts every day. The Berman decision didn't come down, and again, we start signing up all of these cases because we think we figured out something with web forms. We think the principle in a series of cases that we've litigated recently having to do with web-based opt-ins, we think things are becoming more and more clear. And the reality is you just have, you may have a moment in time where you're making some calls that you otherwise wouldn't be able to, or you're generating some leads and turning those into some conversion. But that's just going to be a moment in time if you're not doing front-end due diligence on your web-based leads. And that means you know, and I don't know if it dovetails with the other things that you desire to discuss, Eric, but if I'm in the lead generation and lead purchasing space, and I'm not personally talking to someone that operates the website that I'm getting the data from, I think I'm doing it wrong. Like, I don't care if you've had a 5-year, 10-year, 20-year vendor relationship with someone that's generating leads. But when it's my business that's going to be on the line, and my business subject to potential nationwide class actions, multiple of them, because as you know, a lot of these cases get filed, then you think about it in terms of any material asset for your business. For a lot of these businesses, leads are going to be your lifeblood. And you have a responsibility, and frankly, it can be a self-interested responsibility, to really dig in on where those leads are going to be coming from. Because like I was saying earlier, we see too many reactions to lead issues as opposed to, hearing about what I don't hear enough of is, I was told the leads were going to be generated in a certain way, and they were actually generated in a different way, right? That's that here nearly as much as, oh, we were told it was going to be done lawfully. And and that's what Joe said, and I've known Joe for a while, and sure, Joe was working with Jim, but he said Jim's a good guy, and then Jim has Tom, but Tom has really cheap data, and he has a contract, so.
Well, so let me ask you then, Mr. Wolf, would it move you if you were talking with a caller? Because, I mean, you'd agree with me that most of the time the callers are trying to actually contact real consumers who actually want their product, and they have contracts in place with lead suppliers who are promising that these are real, valid leads with express written consent. And the caller wouldn't be calling without that contractual assurance. So would it move you if, beyond just having the contract, the caller actually said, hey, look, I talked to the lead supplier, I demanded to know every publisher that they were using, I looked at every one of those websites, the disclosures looked great, I personally talked to a handful, because as you know, they might have hundreds or thousands of publishers that an aggregator might work with, right? I talked to them, I re-emphasized the importance of only supplying the aggregator with good leads. I told the aggregator a second time, we only want good leads, don't give me somebody you just found, no pilot programs. Would that sort of thing move you and help you to feel more comfortable about perhaps letting go of a case? Or are you thinking that's just, that's all well and good, that's prophylactic, but at the end of the day, if you screw up, it's still strict liability, so we're going to come after you?
Yeah, no, that's a really good question, and I'm sure it's an answer that a lot of people want, and I desire to give like common sense and practical answers, but it's hard to talk about that in the abstract without knowing exactly the circumstances of each of the campaigns. But what I do know, and what I am comfortable saying, is that if we're looking at a case and the contract says you have to generate leads from this website, and you lead vendor, anytime you don't generate leads from that website, you have to write to us, you have to get our written authorization before you go to a different website, and if you don't, you're in breach of our agreement, then that I find much more compelling in terms of if we're throwing everything into kind of either a risk matrix or like an ethos matrix, right? And I find that much more compelling than well, I don't know, he says, he or she says there's consent, right? Like so isn't that the end? That stuff, that stuff really sticks out to us. And I don't know if it is consistent with what you see and you experience, but I know from my side of things, something that always stands out is, are you going to put your money where your mouth is as a defendant, which is, if this lead generator, you're giving my client, my co-counsel, and I a narrative that this lead generator did you wrong, violated your agreement implicitly, explicitly, on a blood oath, whatever, then what I'm always interested in, because we're, people on our side of the V, every case I've ever filed, right, there's been a phone call where they're telling us why it's not the right case for us. So we're used to that. And we understand that that's part of the job. but I'm interested, are you suing that lead provider, right? Are you bringing them in as a third-party defendant, or are you just here to whine on the phone to me about how unfair life is? That, I think, is something I can speak more concretely about. Hey, does that move you? Do you believe a lot more of what we're saying? The proof's on Pacer, right? If they did it wrong to you, then make sure that you're vindicating your rights instead of, just giving me a sob story. Because I'll listen, I'll process, but I'm also going to react to how you react.
Well, speaking of reactions, so many folks in the lead gen industry, I see this all the time, they're very upset with the professional litigators. Of course, the Wolf is well known for representing folks that maybe not professionals, but certainly repeat players. Is that still going to be a big part of your arsenal, Mr. Wolf? You're going to keep going back with the folks that have been here before, or are you branching out and taking maybe some referrals from some first-timers?
We've done both, but I don't use the word professional, and I know you weren't doing that in a way to offend, so I'm not offended. But what I say is experienced litigators, I think, serve as the best class representatives because of their experience. So they're participating in the litigation. They're participating at really every turn of what we're doing when we're trying to recover for other individuals who have been similarly impacted. And there's a big difference between someone who knows their rights, knows how to react to what they're doing, and it doesn't mean that they're any more or less harmed than the person who just looks at the phone, says, what the heck, slams it down, and is annoyed, but is uninitiated or uneducated with respect to what to do. So I mean, I guess a direct answer to your question is, I've always, when I litigated these cases at prior firms, on my own firm, and at different times in my own firm, I think experienced litigators are, in a lot of ways, some of the most important individuals that touch the TCPA.
And when we're talking about experienced litigators, I mean, Johansson was one of them. I know there can sometimes be the impression, and certainly, folks on my side of the V and my clients are quick to jump on this. I'm not saying it's true, I'm not saying it's not true, that many of these folks are inventing their own claims. I imagine in your experience, that's not what you're seeing on your side.
It's definitely not what I'm seeing on my side. What that is, right, is kind of more of this. I usually hear that right before or right after I get the part about how Joe, the lead provider, was a good guy and I don't know why he did what he did, right? So then when that doesn't work, then what I next hear is, oh, well, the individual you're representing, they filed 7 lawsuits. So first, as a heads up to all the attorneys out there, is because I know Eric doesn't ask me this, but yes, I know. Like, I do know how to use the internet. I'm a decent reader. So I do know that they have filed these cases before. What I also know is that if an individual is experienced in litigation, I have had 0 experiences with someone that I have represented multiple times. And again, 0 experiences with them going onto a website, signing up for something for the purpose of initiating litigation. That's definitely not a sensible business model for someone on my side. And that's economically risky for the individual themselves, because if you're, not your clients in particular, but if there are call centers or lead purchasers out there that think individuals who are repeat litigants, I guarantee that they're realizing less money from this than what their assumptions are. So it's not, like I said, and I'll repeat myself, it has been an experience 0% of my time that an individual I've represented multiple times I've ever seen do, I guess what the accusation would be, is planting evidence on the internet. What I have seen plenty of times, and what I think can make defendants frustrated, but I care even less about, is the fact that those individuals, in order to obtain the information that they believe is necessary to support a claim, that they stay on the phone, right? So that's a conversation I have with a lot of uninitiated TCPA defense lawyers, which is, well, the fact that they were on the phone for 8 minutes, wouldn't you agree that that means they went to the website? Because of course they were interested and this incredible $730 a month, $10,000 funeral insurance policy. And no, that is not my experience. My experience is that when someone is called illegally, and this would all be much easier if all the pre-recorded messages out there identified with appropriate federally mandated specificity who was calling. Unfortunately, that's not the reality. So staying on the phone and understanding who's contacting you illegally is very typical, and I wouldn't say universally endorsed, but that's only because I can't think of a federal court that has said, hey, by staying on the phone, you have more of a statutory violation if you were only contacted for 8 seconds versus 58 seconds.
Now Johansson did kind of, he stubbed his toe with the federal court finding that, feigning interest was at least something that in some contexts the court was uncomfortable with. But I hear you that there might be a difference between that and staying on the phone as like a canary trap to figure out who you're talking to. And you don't have to comment on that if you don't want, although obviously I'd love your take.
I don't think I have like a particularly meaningful take other than in the Johansson case I'm thinking about, we were pleased with the 11th Circuit exercising its discretion to accept the 23F appeal on that issue.
I did not know that. So this is the wolf. You never toot your own horn. You should have sent that to me. Some plaintiffs' lawyers, you may know, anytime they get a win, they immediately send it to me because they want to see their name in ink on TCPA.
Is that how I can move up the final 6 rungs of the rank?
I was gonna ask you, Anthony. Now I assume that you, like everybody in the TCPA world, were waiting with bated breath for my power rankings. I thought you came in 5. Did you come in? I should have looked that up before I got in the interview.
Probably shows how locked in I am to them. I might have been 5 or 6. I knew enough to know I wasn't 1 and that I had work to do.
Now how did you feel though?
The more you file, you go down in the list.
Were you? But were you?
Well, I'd like to take this opportunity to announce my retirement.
We want you off the list, is what we're aiming for.
Well, look, I'm curious. I'm going to ask all the plaintiffs' lawyers I have on. Did you feel comfortable where you were slotted? Like, I had to put a boss above you. Berger and Fisher had that huge, the world-changing settlement, the highest settlement of all time, and of course, Greenwald has just been cracking people with this. I characterize it as ridiculous, but it's also brilliant. Hide the ball strategy on recycled numbers. So I felt like I slotted you in appropriately, given not necessarily how dangerous you are. I think you're one of the most dangerous litigators, maybe the most dangerous litigator out there. But just in terms of recent, huge rulings. And so I didn't mean to be disrespectful, but I was curious kind of how you felt about how that list came out. Was it well received?
I wasn't disrespected at all. I think everyone that was ranked above me completely deserved it, and I'm sure there were people below me that deserved to be above me as well.
Well, I appreciate it. All right, so last question, Mr. Peronic. Look, well, first of all, thanks for being on the show, man. I really appreciate it. Again, you're our first guest for the new show. I can't think of anybody that my audience would rather hear from than you, frankly. In the old days, I had Jay Edelson. I've had a boss as my first guest. Today, right now, in this world, you are the guy they want to hear from. So, in that vein, I'm just going to ask you directly, the wolf of TCPA world, how can callers, call centers, or people in the world, you want to talk about life more broadly, how can they deserve to win?
Yeah, they can deserve, and it's a good question. I'm sure it gets to the heart of what your listeners want to hear, both from you and from the people that go against you. And the reality is what they can do is do more and speak less. Right. So what they need to do is, and this is a legal podcast, but it shouldn't be a surprise to hear. If you really care about avoiding TCPA lawsuits, your representation needs to start at inception of lead purchase. And what I mean by that, right, is as soon as you decide that you're going to be purchasing leads, you need to be talking to a lawyer that knows what they're doing about that. And Eric, you're one of them, but you're one of them. Right? It's not like these people are impossible to find. They're not difficult to find. They want to help you. But the reality that what stands out to me on these issues, and it comes up in cases we've litigated against each other, cases that have nothing to do with either of us, but I know they're common threads throughout these litigations. Way too many lead purchasers are reactive to problems instead of getting out and getting ahead of them. So again, what matters? What do I hear? Understanding that the facts of each case can be different, but the common threads that matter to us is, are your lead sellers, like if they violated your agreement, are you suing them or are you just complaining about them? And in addition to that, what did you do in order to not be surprised by this? Because if what you're coming to our side with is, well, they have an agreement that says they're an independent contractor, we're rolling our eyes, right? If they say that, well, they told us that it was going to be fine, we're rolling our eyes, right? But if you got to be, what's the right word? I think you got to be aggressive in litigation, right? This isn't just a get along to play along world with telemarketing. It's big business, it's big liability. So if someone is doing something to you that's wrong, that's inappropriate, that's in violation of your agreement, hold them accountable for it. And don't necessarily just look to the individuals that are educated, that are willing to take on and carry the water and be deposed by Eric for 7 hours and willing to file these cases. And I think this dovetails right with the conversation we had on a prior podcast, that once you can kind of disassociate yourself from thinking that, the boogeyman's coming to get you, I think it'll cause a lot of businesses to take a fresh look at what their lead generation process is like. And maybe your lawyer will disclose it to the other side. Maybe they won't. Maybe it will impact their decision or not. But whenever I've seen a defendant that's engaged in a real compliance audit and effort, unless they're doing what they should be doing on the front end, and that's not many companies, then they're going to see areas for improvement and really potentially pitfalls that they're avoiding. So what they can do is, they can do more and say less, and doing more starts with good, sound, quality legal representation. And when they get sued in one of these lawsuits, the boogeyman, if that's what caused it, he or she will be there at the end of your internal audit and analysis. But starting from the assumption that someone's out to get you, that's just inconsistent with reality in my experience.
All right. Well, there you have it. Thanks so much for being on the Wolf of TCPA World. Let's give him a round of applause. Thanks, man. Well, that was absolutely fantastic. I don't know how you guys felt about this. I guess we're going to find out right now. The Wolf, he's a scary guy. I mean, he is a very talented lawyer, very successful. Let's throw it around, PJ. Let's start with you, buddy, because I know you've tangled with the Wolf a couple of times. I know you've got some views.
I have not tangled with him.
Okay.
I've been lucky to avoid the Wolf.
All right. So what do you think, man?
I think he's very sharp. He's very smart. I don't agree with him saying that litigators don't opt in. I think that we will eventually catch someone, and I can't wait to see that day.
I mean, I think they've been caught a couple of times. I mean, Barton just got hammered today. Literally, as we were driving in the Western District of Washington, a court came down with an order saying that he owes $40,000 because he submitted a consent. I mean, so it's not unprecedented, but so you think there's a lot more of that going on, though?
I think there's a lot more of that going on. I definitely think there is lead fraud going on as well from some of the lead generators. And I agree that that space should have some sort of framework that, hey, look, this is a big company. You have indemnification. You've done your due diligence on them before you're buying. I definitely agree with those points. Yeah. But to say that none of these litigators opt in, I don't know. I think that's going on more than we think, and I think these litigators are smart about how they're doing it.
Oh, we think it goes on a whole lot. It's just a matter of how can we prove this. Merlin, we need your powers, man. Let's get that done. All right, let's throw it over to the Baroness. You're like the rookie. I'm not sure. Maybe the rookie is going to be your name more than Baroness. I'm not sure. I'm just kidding. Look, you've only been doing this a short time. Mm-hmm. You've been absolutely fantastic. You are fantastic as an attorney. But Peronic, the Wolf, I mean, that guy's top drawer. What'd you think?
I mean, it's interesting to see, you know, I've been working with you and everything on the defense side of it, but it's also interesting to see what things look like on the plaintiff side and getting his perspective on things and what he likes to see, what catches his eye in these litigation cases, and what common themes are on that side.
Yeah, but you can't be low-hanging fruit. I mean, he pretty much just spelled that out completely. I mean, did you take some takeaways? You helped me with some of the compliance work. What do you think? What's like jumping out at you on things that we're going to have to like really kind of focus on moving forward?
I think what stood out to me was he was saying that a lot of these vendors have to do their due diligence on the front end and make sure they're really obtaining consent the right way. So I think that was interesting.
Well, I'm going to end with Queenie because, I mean, Peronic was just throwing softballs at you. He basically said out there, hey, look, if you're buying leads and you don't have in-house counsel, if you don't have a GC, if you don't have someone doing phenomenal vendor intake, then you're in harm's way. And I just saw you over there like, yeah, like ready to jump out of your chair. Okay, Queenie, now's your chance.
Well, I mean, I preach it over and over again at these conferences, right? Compliance, 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 cut, right? For lack of better words, that's what Peronic said, right? He basically said, cut the bad actors and also take compliance very seriously. He's sick of just hearing words. He doesn't want to hear what you're going to do. He wants to see you being proactive about what you're going to do and what your compliance efforts are. You know, you work at a company like Digital Thrive, you know, I'm in-house, I work with Eric Troutman. Hopefully we don't have to work with Eric Troutman, but for compliance advice and whatnot, we take it very seriously. Previously, I was at Loan Depot, same thing, right? You have to look at the companies that are hiring in-house compliance TCPA attorneys. And sure, you're not going to get everyone with TCPA experience, but you know, that's a telling sign that if you have someone with experience who's taking it seriously, the company therefore is also taking it seriously.
Well, I just thought it was remarkable that he basically begged lead buyers to sue the lead sellers for fraud. And when you were at Loan Depot, I mean, look, it's public record. Loan Depot went after people for fraud in federal court filings, specifically to make sure that they were not an easy mark.
I think we were the first of the buyers to come out, at least publicly, and do it, and you have to hold them accountable. Like, you all saw the article I just posted last week on TCPAWorld.com with QuoteWizard just going at it, you know?
Yeah, there's just no choice, absolutely no question. So I know, and thank you, by the way, Queenie, you showed great restraint. I know for you in particular, it's challenging to hear from the other side, but we can't live in an echo chamber. We have to give both sides their due.
I agree. And when you just don't use the word fantastic and Peronic in the same sentence next time, and I'm okay with that.
That's fair. So look, what I want everyone to take away from this is just how good and sophisticated the plaintiff's bar is. Understand what he told you today, okay? I hope you heard this. He says, we are looking for fraud cases. We are looking for cases in which the plaintiff says, I never went to the website, and the lead buyer was buying leads from a downstream source, right? But their theory, even though they're looking for fraud, their theory in Berman, their theory in these cases is a pivot, because they know they can't certify the lead fraud case, but they're after the protection of a lead fraud class. So what do? They pivot to their second best argument, which is a web format, web layout, web disclosure class. Because why? Because that's a common issue across the class. So imagine how good these guys are. This is their second or third best argument. Their best argument is fraud, but they can't do that on a class-wide basis. They get to do that to the jury at trial, but they can't do that on a class-wide basis. So imagine how good a lawyer you have to be to win, to beat sophisticated counsel, not Eric Troutman, but other sophisticated counsel with your second or third or fourth best argument. And that's what these guys are doing, all right? You heard what he said. He used the word appetize. You do not want to appetize the wolf, okay? My goodness, that's not where you want to be. Avoid the fraud. Do your compliance work. Do your vendor diligence. Get yourself good counsel at the outset and protect yourself from guys like the wolf, because when he comes knocking, there's nothing you're going to be able to do. There's nothing, right? His third, fourth, fifth best argument is still good enough to crack very sophisticated companies. You just have to hear it. You have to understand that the only way to win these cases, you know, it's like the old war games, right? The only way to win the game is not to play. You want to deserve to win, folks. Listen to the wolf and take compliance very seriously. All right, folks, well, that is it for our first episode of the Deserve to Win podcast. Of course, coming to you from the wonderful art studio here in Santa Ana. This was fantastic. Any last thoughts, guys? Any closing thoughts before we leave? Just want to say bye to everyone.
Thank you to our producer. You can't see him, but he's wonderful. So.
Yes.
Yeah, this was fantastic. And thank you, all of you, for watching. TCPA World will continue to bring you great content, of course. The Troutman firm, always here to help defend you. You're our friends. We care very deeply. We want to keep you safe. Until next time, this has been the Deserve to Win podcast, and we help you to deserve to win.